Thanks, Lloyd, and thanks to the board for the invitation to be here. I'm always happy to be here and provide updates on the regulatory landscape nationally and in Wyoming as it pertains to the energy industry. Just a quick overview of the topics that I want to cover. As Lloyd mentioned, there are a lot of federal regulations out there, and I'm going to focus in just on a few in the interest of time. First, I'll talk a little bit about the Regional Haze update. I've made presentations, and others have made presentations on Regional Haze and the Regional Haze regulations, so I won't spend a lot of time rehashing that, but rather focus on an update there. And then talk a little bit about what's on everybody's mind right now, which is the new source performance standards for new coal-fired power plants or electric generating units, more specifically, and CO2 regulations associated with those. And then third, regulation of existing electric generating units and CO2 emissions. And then lastly, cover other topics of interest. Before I get into Regional Haze, I thought I'd just kind of poking around the Energy Information Administration's website. So just a few trivia kind of thoughts as I go through the presentation. The first one that I thought was just of interest is sources of electricity generation in the United States as of 2013. You can see coal is still the leader there at 39%, natural gas at 27%, renewables are at 13%. Putting that in context of Wyoming, the energy produced in Wyoming, 89% of that energy produced in Wyoming is from coal, and then roughly 10% is renewables, predominantly wind energy. Okay, so just a little bit about the Regional Haze program. A little bit of background, get everybody back up to speed. The Regional Haze program came about from some amendments to the Clean Air Act in 1977. But some key points: it's a program for protecting visibility in national parks and wilderness areas, and these are defined as your Class 1 federal areas. Again, it's a visibility program. The national goal of that program is to restore visibility, addressing man-made causes of impairment of visibility, making reasonable progress towards that goal by the year 2064. And again, I just reiterate that this is a visibility program, it's not a health-based program. We have national ambient air quality standards that address health-based issues. And it's also not a climate change program, although it affects similar industries. Okay, now if you recall from previous discussions, the Regional Haze program basically has two components. There's a component that deals with a state implementation plan that addresses sulfur dioxide emissions. That's under one portion of the Clean Air Act. And Wyoming submitted its plan, and it was approved by EPA in December of 2012. Now, a month later, a lawsuit was filed by Wild Earth Guardians in the 10th Circuit challenging EPA's approval of Wyoming's plan. And the argument by Wild Earth Guardians is that the plan failed to meet standards that EPA had revised after Wyoming submitted its plan, but before EPA approved the plan. Think about that for a minute. Now, Wyoming's not alone in that arena. Wild Earth Guardians also has challenged these sulfur dioxide plans for Regional Haze in Utah and New Mexico. The 10th Circuit made a decision to consolidate all the cases into a single case, and Wyoming has intervened in those discussions, and so that's progressing Okay, the other half of the equation with Regional Haze deals with particulate matter and nitrogen oxides. And this has, in Wyoming, has been a long path for us to get to where we are today. So we submitted our state implementation plan in January of 2011. And subsequently, there have been 3 different versions of EPA's review and approval or disapproval of components of that plan. The first one came in June of 2012, where they partially approved, partially disapproved. They approved 6 of the, well, let me back up. A large component of the early submittals of the state implementation plans is to deal with certain sources and make best available retrofit technology decisions for those facilities. Primarily, we're talking about our coal-fired electric generating units. We have 15 units within the state that are subject to this BART determination. So in 2012, EPA approved 6 and disapproved 9 of our BART determinations. Went out to public comment, and somewhere in the middle of that public comment process, which never really was completed, EPA made some additional changes in consideration of certain comments that they had received, and revised their proposed federal implementation plan, where they approved 5 of our BART determinations and disapproved 10. After the EPA came out with that re-proposal, there were a series of public hearings where EPA took additional comment. And after taking comment, we were somewhat encouraged that EPA then went back and they changed their BART determination review, where they accepted or approved 10 of our original BART determinations and disapproved 5. That's where we stand right now. That's EPA's final determination, and EPA, the state of Wyoming, has sued EPA over that decision to partially disapprove. Now, I can't say a whole lot about that because obviously we're in litigation, but what I can tell you is that the primary reason, one of the primary reasons for our decision to sue EPA over that decision was their plan essentially gets to the same place with improving visibility as the state plan. The primary difference is the federal plan would cost industry more than $500 million more to get to that same place. Now, obviously, that's our position on it, and if you asked EPA, I'm sure they'd have a different story to say. Okay. As I mentioned, we're not the only state that's been impacted by decisions made by EPA or third-party lawsuits relative to regional haze plans. Specifically, Oklahoma and North Dakota, they have sued EPA over their disapproval of regional haze plans. Right now, where that stands is that Oklahoma and North Dakota have petitioned the Supreme Court to review an appellate court decision that upheld EPA's decisions. Wyoming and several other states have filed briefs supporting the petitions of Oklahoma and North Dakota. So once we get to the point where we have final plans, the next step has been to the courts, and that's kind of where we're at right now. That's not the best place for certainly the facilities to be in, where we have the agencies in this dispute. So hopefully there's a quick resolution to these issues. All right. So I'm going to jump off of Regional Haze and another trivia piece here. Again, some information that obtained from the Energy Information Administration's website. as we jump into discussions about carbon dioxide emissions. I thought this was of interest. What this graph shows is the energy-related emissions since 1990 to 2012. And if you study this graph a little bit, what you'll see is that the reported 2012 carbon dioxide emissions from energy-related sources is at the same level as the 1993 levels. So there have been, you can see the reductions in recent years for probably a variety of reasons, but I just thought that was of interest as we get into this discussion. Following up on the previous slide, what this slide shows is a different timeline here. We're talking 2005, really with real data until 2013. The out years are projections. But what you can see, and it ties back to the previous slide, is that many of the reductions in emissions have come from the coal generation. And coal being the bottom part of the bar. Okay, so where are we now relative to the regulations that EPA has proposed for electric generating units to control CO2 emissions? A little bit of background. The first attempt at developing regulations was back in 2012 for CO2 regulations. EPA received a large number of comments on that first attempt, over 2.5 million comments. Their response to that was to withdraw the proposal and make some adjustments. Since that time, as many of you are aware, the President came out with this climate action plan, which in June of 2013, which, among other things, had a call to EPA to address CO2 emissions from electric generating units. It also asked EPA to take a look at standards for vehicles and address transportation emissions and other things. So this was one component of the President's plan. And it has a very aggressive time schedule associated with it. So EPA then announced its revised proposal in September of 2013 and came out with and published their proposed rule for new sources of electric generating units in January of 2014. There was a comment period that was extended. The comment period ended here just recently on May 9th. And the department submitted comments, pretty lengthy comments, on that proposed rule. The governor also sent a letter to the EPA administrator commenting on that rule. One thing I do want to point out, in the discussions you'll hear reference to Clean Air Act 111B. Actually, won't even hear the Clean Air Act part of it, you just hear 111B. 111B just pertains to the provision in the Clean Air Act that EPA is using to move these rules forward. So 111B is for new sources, 111D is for the existing sources. So when you hear that discussion, so you understand the vernacular there, but keeping in mind that the importance of 111B, even though there aren't any projections for new coal-fired power plants to be built at this time, you have to have 111B regulations in place in order to have 111B. You can't have 111B until you have the new source. That's just because of the requirements of the Clean Air Act. So that's why EPA has come out with this proposed rule for the new sources. They have to have that in place. Okay, so now, as I mentioned, we had extensive comments on 111B for the new sources. I'm just going to hit some of the highlights. It's a pretty lengthy document. Some of the concerns that we had was the statements that EPA has made that partial carbon capture and storage is adequately demonstrated for purposes of this rule. In our view, it's not adequately demonstrated. And there's a difference between achievable or technically feasible and adequately demonstrated. There's a nuance in there. But essentially, we know that we can do enhanced oil recovery. I mean, Wyoming's been doing that for a very long time. And you can use CO2 for that purpose. However, to make that a component of an electric generating unit for a new source, there are, and you've heard some of those here earlier in the discussion, is one, it's very location dependent. There are other factors that need to be considered when you're making the demonstration that it's adequately demonstrated. For example, there's cost of achieving the result. Some of the facilities that are relied upon by EPA in making this determination that it's adequately demonstrated include, well, for one example, there's a facility that had an original budget of $2.8 billion, and currently they're $2.3 billion over budget. So it certainly raises question about, is it adequately demonstrated in our minds when you look at some of the information that they provided as their justification. Another one to mention is the system impacts on the environment. So with carbon capture and storage, you are addressing one issue in terms of capturing the CO2. However, there are additional expenses that may not be accounted for in their evaluation that we think they need to look at. For example, the energy that is required for that carbon capture and storage equipment. You're going to be burning more energy or more coal, presumably, which will then result in more emissions of SO2, NOx, particulate matter, in order to maintain the same level of output at your facility. So, some things that need to be considered and factored in during their evaluation. The next item was the definition of new sources in the Clean Air Act includes modified facilities or reconstructed facilities. EPA's proposal for the new source performance standard differs in the definition of what a new source is. They exclude modified and reconstructed sources. And at some point, they're going to have to reconcile that. But they've redefined what a new source is through this process, which is contrary to the Clean Air Act. And that's just something that needs to be reconciled. And then lastly, and I think you've probably heard this one before, is that it relies on many projects that receive federal funding and grants to make their determination on adequate demonstration and technical feasibility. This is contrary to the Energy Act of 2005, and it is problematic, I think, for EPA down the road as to how do they justify developing a rule that contradicts the requirements or violates the requirements of another act. All right, let me jump to existing electric generating units. This has garnered a lot more attention for a lot of reasons, but one thing that I would say is that I think EPA has done a very good job of outreach in this effort. They have created ample opportunities for all stakeholders, whether it be the industry or the states, to participate, to provide input and feedback into this process. And I would commend EPA for that effort and their willingness to reach out and listen to what all the stakeholders have to say. In particular, Janet McCabe, who is the Air administrator for EPA out of DC, Joe Goffman as well. The two of them have been very open, very active in this process. So, just some quick updates here on schedule, and this is one of the issues that we have. We haven't seen, EPA has been very tight about releasing any information on what this rule will look like. Their proposal is expected to come out June 2nd. Gene McCarthy made that statement a day or two ago. There was some question whether that was going to be delayed. Bob Persicetti, the Deputy Administrator for EPA, had kind of hinted that they may be delayed to the end of June. But Gene McCarthy a few days ago made certain that we knew that June 2nd was the date that they're going to come out with their proposal. So that'll be a busy time after June 2nd as we review how EPA interpreted the input from the states and from the industry and from the other stakeholders. We just don't know at this point. Now, when you look at the schedule, their target, their mandate is to have the final rule in place by June 1 of 2015. So they have 1 year from the time that they come out with their proposal, essentially, to finalize that rule. So they'll be very busy as well, because they will be receiving numerous comments and engaging the states. And one of the things that, as the states that we've requested of EPA, is that they continue this dialogue that they've created over the last 6 months, this robust discussion, and it's going to be even more important for that discussion to continue once the draft rule comes out. Now, the part that gives the states, many states in concern is the next date, which is the states would have to have their plans in place by June 1, 2016. Typically, states have up to 3 years to submit their state implementation plans on new rules, because oftentimes you have statutory changes or rule changes that you have to incorporate before you can submit your state implementation plan. There's a very aggressive schedule, and we're concerned about that, primarily because if we can't meet those timelines, are we setting ourselves up for further lawsuits for missed timelines? And so we want to make sure that that doesn't happen. So we've made those comments and that known to EPA. Okay. So in these discussions that have been occurring over the last 6 or so months, maybe longer, the DEQ and the Public Service Commission here in Wyoming have been engaged in those discussions. We've had meetings throughout the country, Florida, Oregon, North Dakota, wherever EPA is. We try to be there to hear their feedback and to give them ours. I did want to make a point that there's this coalition of states. There are 15 states that had sent a letter to EPA expressing their views and sharing their experiences in regulating CO2. And those states, I'm not going to read them off, but they include what's called the RGGI states, the Regional Greenhouse Gas Initiative states. And they have their experiences, and they have different circumstances, different economic factors, different industries driving their economies. And it was important that we recognize that. We don't necessarily have this, I don't want to create a divide between these states and the other states. They just have a different view because their situations are different. It's not right or wrong. But as we were having these discussions, particularly with our Environmental Council of States, where we have the agency directors from all 50 states having these discussions about these types of regulations, clearly there are some differences. And one of the things that was very evident to some of the western states and the energy-producing states, I'll call them, was that you have this coalition, and they have a louder voice, and it resonates more with EPA. So with the leadership of actually my counterpart in North Dakota, we pulled together a coalition of energy producing states to see if there were common interests amongst those states to have that louder voice, to share those common interests. And it started a dialogue with these states. And we had a meeting back in April up in Bismarck, North Dakota, which included industry, included the states, EPA, and the Environmental Council of States. So had great participation, starting to outline what are the real issues that energy producing states face that need to be heard by EPA. So we make sure that those are addressed as they move forward with the drafting of their regulations. Okay, and I'm just going to hit a few of the highlights here. The energy producing states will be staying engaged. We're looking at potentially drafting a joint letter that would be sent to EPA. That's a work in progress right now. But some of the considerations that we were talking about, and you'll probably hear about some more of this during the next panel discussion, but one is stranded assets. We need to have consideration in a rule that doesn't result in stranded assets. Discussion about allowing the operation of these facilities through the depreciable life. And that gets into impacts on rates. So I know there's been discussion about that. I think that's been received well by EPA. Almir will talk a little bit more about that maybe in the next panel discussion. But it seems like they're hearing the comments and the concerns from the energy producing states. That also falls into the next item, which was grid reliability and affordability. Then we had reasonable time frame for implementation. I mentioned this, it's the 3 years of normal time for states to actually develop plans versus 1. We're afraid, again, if you go with 1 year, we may have some unnecessary lawsuits that could be avoided with more reasonable time frame. And the other thing is that the reality and the environment that we live in right now, we expect that there will be legal challenges to 111B. If there are legal challenges to 111B, that puts that in question what the 111B for existing sources might look like. And so states are a little bit hesitant to move forward too quickly, not knowing what all the rules of the game might be or how they might change. And then the last thing I would mention is just how do you account for, making sure that we account for reductions in CO2 emissions from the point where the baseline is set. So if they set the baseline in 2005, for example, how do you account for any reductions that have been captured between 2005 and present? Is there credit that will be given for that? So those are some of the questions. Okay, so what are the next steps? Under the idea of cooperative federalism, I believe we need to continue to engage EPA in meaningful dialogue. This discussion is going to go forward. We need to be front and center in those discussions, but they need to be meaningful and often once those new rules or the proposed rules come out. States need to maintain the lead in this. It's the responsibility of the states to implement these rules, and that's an area that we've had some discussion with EPA about. It's their role to develop the rules. States should have the flexibility to find ways that work for their states to actually implement those rules. Continuing dialogue with these energy-producing states. I think once the draft rules come out, we'll have an opportunity to re-engage with the list of states. I believe there are somewhere around 18 states that have similar interests in how this rule is shaped. And then lastly, and this really ties to the first presentation, is investment in research and technology. We have to continue down that path, look at clean coal opportunities, carbon capture and storage. We may take the position right now that it's not been adequately demonstrated, but there's work still continuing with carbon capture and storage. We have rules in place here in Wyoming. The piece that we're missing is the financial assurance piece, which is fairly significant. We've taken that to our Water and Waste Advisory Board, so you would expect that over the course of the next 12 to 18 months that we'll have rules that will have gone through our Environmental Quality Council addressing that issue. Okay, so other topics of interest. I'm not going to spend a lot of time on these. I just want to throw these out there to maybe put those on your radar. EPA came out with their proposed redefinition of waters of the U.S. That was back in April. Comments are due to EPA July 21. Actually, it's not just EPA, it's EPA and the Corps of Engineers. The reason that EPA is taking this action, there are two court cases. One was Rapanos, and the other was Solid Waste Authority of Morgan Cook County, which really diminished the reach of EPA's authority on certain waters. Now, it hasn't been an issue in Wyoming from our perspective. We've been able to manage all waters in Wyoming are waters of the state. Our rules pertain to all waters of the state, so even though there's not federal oversight on protection of water quality standards, there's state protections. So really, there are different sectors that are going to be impacted or feel like they're being impacted to different degrees. Certainly it's going to, if these rules stand as written, the regulatory reach of EPA and the oversight of the state would increase. So that's something that we're watching very closely. It does have some impacts, I think, on the agricultural community. But many of the exceptions that are in the Clean Water Act now would remain. The next one is coal combustion waste. Not a lot of update there other than EPA is expected to come out with their proposed rule in December of this year. So we'll be interested in how that comes out. There's been a lot of discussion on whether or not coal combustion waste should be viewed as Subtitle C under the Resource Conservation Recovery Act, which would mean it would be a hazardous waste, or Subtitle D, which would be a solid waste. We're hoping that they're leaning towards the Subtitle D. The way it's been managed effectively to date has been under Subtitle D, and we think it should remain there. And then the last thing I'll mention is on this update is the state implementation plan backlog reduction. Depending on where you are in the country, there are backlogs, or they've addressed backlogs of state implementation plans right now. Region 8, there are somewhere in the neighborhood of 50 state implementation plans that are backlogged. Wyoming has 12 of those. And what I mean by backlog, we have state implementation plans dating back to 1998 that EPA has not responded to. We have worked with the Environmental Council of States to develop a plan with EPA. It's a 4-year plan to eliminate backlog reduction. Now, having said that, we are working with EPA on that backlog reduction. One of the things that I'm not interested in doing is taking back a submittal to clear their backlog. I don't think that's appropriate. We need to find a path forward to get those state implementation plans approved. Now, we have new plans that have been submitted, not new plans, plans that have been submitted that have reached the 18-month timeline for EPA to take action on. And we have, on the last two, sued EPA for failure to meet their obligation under the Clean Air Act. And we're doing that to protect the state's interests. What we found is that there are some organizations out there that file suit when EPA fails to take the action within the requisite timeframe of the Clean Air Act. And oftentimes that leads to the state not being, having a seat at the table to talk about what that schedule is going to look like. So we're trying to protect our interests and continue to work with EPA to eliminate that backlog reduction that they have. With that, I will stop and take questions.
More of a comment. Todd, thank you for your information. I think every time that you've presented to us, you're able to take a very complex issue and boil it down into what feels a lot to me like this common sense approach. And the way you present the facts and how you're working with EPA is pretty impressive. And, I mean, that you're able to maintain such a great attitude and a positive outlook. So really, I wish I was smart enough to ask you a good question, but I'm not. But I do know good work when I see it. And thanks a lot for what you do for the state and also for helping keeping us better informed.
Well, thank you for that, and I appreciate you not asking a question that I don't know the answer to.
Other questions? Other questions from the board?
Just one. I got the impression that the state is not a party to its state implementation plans in front of the EPA, that in fact you have to sue to become a party to be involved in settlements to develop those schedules. Is that true?
Not exactly. Let me clarify that. If nothing happens, then through our normal course of communication, we can continue to push the issue with EPA. For example, with when we did, does that work? For example, when we did the greenhouse gas regulations here about a year ago, we really needed to move those along quickly because we had some applications coming in. We had industry that wanted to get their permits through the state, because what we were ending up with was dual permitting. Essentially, you could get your permit from the state except for the greenhouse gas, which you had to get from EPA, and EPA didn't want to issue those permits because that was taking staff time away from them, the resources that they really didn't have to handle. So we were able to work with them and expeditiously get that particular state implementation through the process. Commendable to EPA and Region 8 working with us to make that happen. It was a very important effort for us. As far as the seat at the table, it has occurred when you have a third party that sues EPA because we failed. Or we didn't, but because EPA failed to meet that timeline. That's what we're trying to protect against, is to make sure that if we file the suit, then we have a seat at the table. And for example, we have a infrastructure SIP for lead. That was the most recent one that we sued EPA over. We missed the deadline, sued EPA, but we also explained to them, we know we're working on this 4-year plan with backlog reduction. That can be the settlement. But we have to put a place marker down. We have to protect our interests, because otherwise you have a third party come in and they start driving the schedule and the priorities. And that's problematic for us.
It's fascinating that your application or your compliance filing, you don't get rolled in unless you sue. Only our government, I guess.
Is that one not working? Okay, other questions?
Gene Freeman, the University of Colorado. I'm curious, has anybody estimated what all of this costs? What is the overhead or the load on the state's funding just to haggle over requirements?
That's a good question, and that's something, that's something that we've certainly been concerned about as well. When, for example, if EPA misses a timeline and they get sued by a third party, not only does that consume a lot of EPA's time, staff time, which makes it more difficult for them to do keep up with the state implementation plans, it's also a strain on the state's resources when that happens, because we spend a lot of time developing a state implementation plan, putting it together to send it down to EPA. The public weighs in on this, the public's interest in all of this, and the time and effort that they've expended to comment on the state implementation plan. When it sits dormant, no action's taken, and sometimes we have to go back and rework that state implementation plan. It's a very costly thing in terms of resources, not only for the states, but for EPA and everybody else involved in the process.
Is there an obligation to report such costs?
There is no obligation that I'm aware of to report those costs.
That's why you have to do that.
Question? And again, there's a mic. Again, identify yourself, if you would, please.
Lionel Rhythm, Basin Electric Power Cooperative. Todd, I'm going to give you kind of a softball question, I think. And I don't know if you're going to stick around for our panel, but I'd like to get your thoughts on this. The U.S. Supreme Court just came out with a decision last week on the cross-state air pollution rule. They basically said the states get one bite at the apple under their state implementation plans. That's kind of the consequence of what they said. The D.C. Court of Appeals had said, well, before EPA, you do your federal implementation plan, you at least have to give the states notice of what the rules is and a chance to implement the rule, and you didn't do that on this cross-state rule, which basically deals with NAC's attainment in the eastern states, eastern of Mississippi. That's the underlying issue, but the legal precedent is what I'm talking about. And you pointed out in 111D the 1 versus 3 year issue. But 111D has two parts. It has a state implementation part, and under the president's plan there, they gave us states basically 13 months to do that. And then if the states don't do it, there's then a federal implementation. 111D2 is a federal implementation, and then EPA can step in and do the plan if the states don't get it done. So can you just talk about that issue in light of that recent decision and the 1 versus 3 year issue you've raised here?
Okay, and I'm not sure I'm going to hit this, Mark. I wish you said this was a really difficult question instead of a softball. But to me, there's a couple of issues here. One, and I've got to back up a little bit, one is that if we submit a state implementation plan and we wait long enough, the rules of the game do change, and EPA then doesn't review our state implementation plan on the current information at the time of submittal. They're reviewing it on new information that we didn't have the luxury of knowing what that new information was, and so then they disapprove our state implementation plan. So that's one scenario, and I find that a very difficult thing to navigate. And another reason why it's important for EPA to make timely decisions, because the longer they wait, the more likely something is going to change, and the more likely it is that they will disapprove. On the 1 to 3 year, if they establish a 12 or 13 month time frame for the state implementation plan and they move forward with it, first of all, I'll tell you that I think, at least my impression is that EPA doesn't want to have to issue a federal implementation plan. If you're talking to the regions, they'll be talking with us, trying to resolve issues before they go down the federal implementation plan route. So I don't think they would come out with a FIP without having those conversations and that dialogue with the state. Even if they move forward with the FIP, we would have some understanding of what's going to be in that FIP. And we would have the opportunity to, really our next course of action would be to either accept and modify our state implementation plan and incorporate everything in the FIP, or to take legal action against the FIP. I don't know if that answers your question, but so you can tell me.
I don't think there's an answer. I think it's an underlying issue you got to watch.
Yeah.
Got a question here? Hi Todd, Greg Shaver with Arch Coal. This is another easy question for you. There's several groups out there like Wild Earth Guardians, Sierra Club, Powder River Basin Resource Council. They're just filing lawsuit after lawsuit after lawsuit. Is there any avenue that you know of to start pushing back on some of that, such as frivolous lawsuits or judicial harassment or something along those lines?
I guess, first off, to be clear, what we're saying is that these organizations are suing EPA.
Correct.
And in some cases, they're filing a suit because EPA has failed to meet a statutory timeline. So the 18 months on a state implementation plan. I don't know that there's a way to push back on that other than one, for EPA to meet their timelines. Or the states that have to take some action to intervene. They are easy targets because they're easy wins. I don't know how EPA argues that those who are making those lawsuits are wrong. It's a pretty easy case to make. And the other part of that, the costs that they incur, their legal fees, are paid for by the federal government when they lose those cases. As far as the rest of your question, I think, is there a way to say they're frivolous and whatnot? I think that's got to come from the federal side of the equation. Not being an attorney, I don't know what our options would be as a state, but other than express our frustration, which we have with the EPA on these issues.
One more question.
Okay, can I do this without a microphone? Is it loud enough? I guess not. Okay, I'm Harry, licensed professional engineer, retired, state of Colorado, teaching University of Colorado. My question is based on what I heard on the Science Channel. I'm an electrical engineer, so CO2 I only remember as a chemical formula. So my question is this: based on what the scientists were saying, that the CO2 emissions by volcanoes dwarfs man-made CO2 emissions. Do you know anything about that? Can anybody help me with that? Justify that, whether that's correct? Which brings me then to the final question. The volumes of CO2 emission that the EPA is pushing down on us, are they really, do they really matter compared to CO2 emissions by volcanoes? That's the question.
I think that's a loaded question, but I don't offhand know the difference between what's anthropogenic and what's not. What EPA is targeting essentially, though, is the anthropogenic portions of the CO2, and their position is that, yes, it does make a difference. That's why they're pursuing what they're pursuing to address the increase over time, the increased amount of CO2 emissions, not just from all sources. We have increased energy demands, we have increased transportation, et cetera. I think that's what they're trying to tackle. But it is the anthropogenic, as far as what the difference between volcanoes and natural sources of CO2 and the anthropogenic, I don't have that answer. Maybe somebody else.